Kelly Peterson. Kelly is a lawyer who has spent his career in family law, largely divorces, their complications, and often how it affects the children who are involved in these things. In fact, Kelly is now specializing in that last aspect, and that's why I wanted to talk to him, because divorce affects an awful lot of people, even if you're not one of the people divorced. And he says the specialty is alienation, gatekeeping, and interference.
Thanks, Bill. I appreciate being here.
Now, I'm guessing that you're studying this and specializing in this because of the negative effect divorce often has, the effect that it has on children.
Absolutely. One of the main purposes of our lives are our relationships with our children and our relationships to our parents, and preserving those relationships is tantamount to our happiness, to our mental health, all of that. And unfortunately, that gets damaged significantly when parentation, interference with parent time, gatekeeping, that kind of thing happens.
Let's not confuse things. It's not the lawyer's fault that people are getting divorced. What is parental alienation?
So an alienated child is one who expresses freely, persistently, unreasonable negative things about the other parent, such as anger, hatred, rejection, fear, that is disproportionate. And that's the key language there. It's disproportionate to the child's actual experience with the parent. Now, and for the purposes of this, what we're going to be talking about today are alienation cases as opposed to estrangement. In estrangement cases, there's actually a basis for the child to feel all those negative feelings about a parent, such as abuse or neglect. But for today's purposes, we're talking about alienation where there really isn't sufficient reason for the child to feel that way.
How does it come? How does it get going, the alienation?
One way that it can happen, and the most disturbing way that it can happen, is through the influence of what I'm going to call the favored parent, the parent that the child is gravitating to. What tends to happen is that the behaviors of the alienating parent impact very much how the child feels about the other parent. Bad-mouthing, limiting contact, over-confiding in the child, discussing the litigation with the child, talking about the negative parenting ability of the other parent, asking the child to spy on the target parent, referring to the target parent by their first name, withholding information from the favored parent or the target parent, undermining that person's authority. Sometimes the alienated child actually quite loves the non-favored parent, but because their relationship with the alienating parent is tenuous, they feel like they have to do what that alienating parent wants, otherwise they'll lose their love.
So what happens? Somebody said it's visitation day on Saturday, and the kid says, I don't want to go visit Dad. And Mom says, that's okay, he's no good anyway, right? Is that the beginning of this?
Right. A typical scenario is the alienating parent first influencing the child against the other parent, and then the child doesn't want to go.
What do you do? I mean, what does the court do? What does a guy like you do? What does opposing counsel do? How do you fix this? This sounds impossible.
So there are all kinds of things that judges, therapists, and guardian ad litems, child attorneys that are tasked, that can do, but there's so many myths surrounding this area. It's a counterintuitive area, and a lot of people just don't get it. They think, hey, the child, let's suppose you have a 14-year-old child, Bill, that doesn't want to go.
Okay.
The typical scenario then is for the favored parent to say, and they always say this, what do you want me to do? Hog tie him and throw him in the car? Do you want me to handcuff him or duct tape him or something like that and throw him in the car? I can't do that. They're bigger than me.
Good question. Even if they're not bigger than you. Good question.
As if that is the only thing that a parent can do with a child who's being resistant. Let me ask you, Bill, if your child, before they were grown up, I understand your children are grown, but it had to come home and said, well, you know what, Dad? I'm going to start using marijuana and I'm not going to school anymore. Just FYI.
And I'm not the custodial parent?
No, that you are. What would you do as a parent to ensure that your child went to school and wasn't engaging in those kinds of risky behaviors?
Well, notwithstanding any divorces that might be involved, I would say, well, we're going to have to see about that.
Right.
Because the law says you got to go to school. And the law says, at least at that time, you're not going to be smoking any marijuana. So, I'm going to have to keep an eye on you. I recognize your rebellion, but we're going to have to fix this. We're just going to have to. That's probably how I have dealt with similar situations with my own kids where I see them doing something or they announce they're going to do something and it's really not the right thing for them to do. And then we have to talk about this. That's what I would do.
Right. And as a parent, you can impose negative consequences on the child. You can take away cell phones, take away driver's license, prohibit time with friends or extracurricular activities.
Yes.
All those things. And that is what the alienating parent should be doing. But and they do often do those kinds of things when it's not getting your homework done or something like that. But when it comes to supporting the relationship with the non-favored parent, all of a sudden now they say, oh, well, what do you want me to do? Handcuff them? And then they just hide behind the child's alleged choice.
All right. I think I see. So the parent who has custody and the 14-year-old has to go somewhere else and doesn't want to, that parent should say things like, maybe, this is what the court has ordered. Your father is really not a bad guy. He and I had some problems. He's not a bad guy, and he is your father. And he loves you, and I think you need to go over there and just hang out. I'll pick you up, at 5 o'clock on Sunday when I'm supposed to.
Absolutely.
Right, but that's a hard thing to do when you're emotionally hating your ex-spouse.
What alienating parents need to realize is they have a choice. Do I love my child more than I hate my ex? And that encouragement that you just described is really only the first step. If the child continues to dig their heels in, they have the whole range of parental authority that they could exercise to enforce and make sure the child goes, even teenagers.
We were talking about the myths of alienation, I guess is what it was. How about therapy? I hear about therapy all the time. And sometimes I hear it works and sometimes I hear it doesn't.
Well, and that is one of the myths that judges and therapists often get wrong. Hey, your kid's not going? Send them to a therapist. Just work it out in therapy. But the research shows that traditional therapy just does not work when it comes to these kinds of situations. And there's a variety of reasons for that. One is that there's going to be resistance to the therapy at all. The alienating parent and the child will sandbag. They'll decide, I don't really want to go. Or once they get there, the alienating child will use it as a platform to simply bag on the non-favored parent, further entrenching themselves in those beliefs and exaggerating and distorting how bad the other parent is, because they think, well, the therapist is going to report back to the court how awful things are for me over there, so I won't have to go. And so traditional therapy can end up being as harmful or more harmful than doing very much in the way of good. The alienating parent uses the therapist and asks the therapist very often to write silly letters to the court saying, hey, look, my child, the child really doesn't want to go. Here's what the child is saying, trying to use the therapist as a supercharge to their argument.
Well, that sounds like we need a little reform in therapy. If the judges are ordering these things, have you been able to discuss that?
Well,
with therapists or courts?
There's a different kind of therapy that is available. It's people call it reunification therapy, but it's not actually therapy. It's more of a reunification process that in severely alienated or even moderately alienated kids, you can send them to this kind of a program, and it detaches them from the alienated parent for a period of anywhere from 4 days to about a week, while the non-favored parent and the child engage in intensive therapy without the influence of the alienating parent around. That is one possible fix that has seen some success, a good deal of success in the research. But one of the myths even therapists will perpetrate is that with an alienated child, if you switch custody from the alienating parent, from the favored parent to the non-parent, that somehow the child is going to be traumatized. And that word gets thrown around a lot.
Yes, it does.
But the research doesn't support it. And if you were to actually put an expert on the stand to talk about what is the research about whether or not moving a child from a favored parent to a non-favored parent is going to traumatize the child, the expert is not going to be able to point to any research that says that that's true.
How do you do it, Kelly? There are many forms of law specialties that you could have gone into. I mean, there's people that do real estate law, they do wills, they do personal injury attorneys, and on and on. Those are not emotional things. I mean, yes, if you have to go to court, you have to go to trial about anything. It usually involves some emotions, but this is the most basic instincts and emotions that human beings can have. How do you get through this stuff?
It's stressful. A lot of attorneys, I don't know how many times I've heard from criminal lawyers, personal injury lawyers, and other attorneys that I know say, there's no way I could do what you do. There's a reason why judges, family law litigation is among their least favorite kinds of cases to hear.
Oh, I'll bet.
It's stressful, it's emotional, but here's the thing, Bill, it's also meaningful.
Okay.
I can't say that I enjoy working on these cases, but what I do find is satisfaction in it. Because when I'm able to help a family or help a non-favored parent reestablish a relationship with a child that otherwise that child would have suffered long-term mental health problems, inability to attach with others, increased likelihood of drug abuse, increased likelihood of domestic violence because of a severed relationship with a parent. I mean, the list of horribles goes on for a child who is alienated. When I'm able to help reestablish that connection, it's difficult, it's stressful, but it's also tremendously satisfying.
You're specializing in this to try to solve some of these problems. How can you do that?
So much training goes into being able to specialize in this area. There are so many myths surrounding it, and being able to effectively represent a client where alienation is involved, it's an extremely difficult area of an extremely difficult area, to the point where judges, therapists, and attorneys often don't know what to do. They're befuddled by the situation. What can be done, there's a lot of things that can be done. Let me give you some examples.
Yes, please.
One example of something that can be done is where severe alienation has been happening or long-term moderate alienation has been happening. One thing that the court can do is switch custody from the alienating parent to the non-favored parent. And as I indicated before, the research does not support the idea that the child will be traumatized by that. One of the things that judges unfortunately think are going to be effective is a good stiff lecture from the bench. And the research does not support that helps. Every judge thinks that they have this speech, right?
No, that's why we have criminals going back. If I ever see you in front of my court again, I'll throw the book at you. It never works there.
Exactly right. And it never works in this case either. But every judge thinks, well, I've got this speech that is just so calculated for this problem that it's going to scare the other side into submission. And it doesn't. Other things that judges or inexperienced attorneys or therapists think will work that don't. Traditional therapy, we've talked about that. A cooling off period. And this is a big one. The favored parent or the therapist or the judge will say, well, we're going to give a cooling off period where, Dad, why don't you just take, or Mom, whoever the non-favored parent is, let's just take a step back from your visitation for a while so that the child can cool off. The research does not support that works. As a matter of fact, what that does is it emboldens the child and the alienating parent to continue to make false allegations or things. And so what does work? You can award the non-favored parent additional parent time and makeup time. You can, we talk about changing custody. Here's some language that I've also often advocated and been successful, and very often this has worked. That each parent is specifically directed to enforce the court-ordered parent time, and that the children are not to be given the choice whether to attend. They are ordered to do so. So if a child is refusing to go, the favored parent has to increasingly escalate consequences until the child goes.
Yeah, okay.
and is to not give a soft place to land. You say, hey, you can't stay here, kiddo. You've got to go there, and you're not allowed to be in my house while it's the other party's parent time. And by the way, I'm not going to tell you, and this can be in the court order, that when providing consequences, I'm not providing consequences because the other side is making me do it. I'm doing it because that's my job as a parent, to support the relationship with the other parent. And your relationship with the other parent is so important that it's me taking this step, not the other parent, because very often they'll try to blame the other parent. Hey,
and what do you do in court? Do you tell his honor to say his or her honor to say these things, or
absolutely?
Okay, you're specializing in this.
Absolutely.
It's basically you standing before the court or filing motions to say this is what needs to be said to my client and maybe the opposing counsel. Absolutely.
So we've also talked about these short, very specialized programs. There's several of them across the country, but you can send them there for a week or less. There are some cases, and these are the cases, Bill, that are so perplexing as to make judges or therapists go cross-eyed when they see them sometimes. And that is, what happens when the child starts threatening suicide or starts threatening self-harm? If I have to go with the other parent, then I'm going to kill myself, or I'm going to run away or engage in some risky behavior. And there are ways of handling that as well. For example, emergency rooms or residential care don't get used often enough in those situations. If the child is expressing those kinds of things, then
suicide, take you to the emergency room?
Absolutely.
Really?
Absolutely.
Okay, I've never heard of such a thing.
Well, because they will assess their safety, and if the child is truly suicidal, they're going to admit them, and because that's a mental health issue, and they need to get some treatment for that until they're safe. But one of the counterintuitive things about alienation is, and let me ask you, who do you think that the child should be released to when they're done with treatment in that situation?
Oh, well, I suppose what his or her honor declared in a decree who should ever have custody. That's who I think it should be released to. So I guess whoever it came from. But that's counterintuitive, too, because that caused the problem. But that's counterintuitive because if you send it to the other person, they still want to commit suicide. So I don't have a good answer, I guess.
Okay. So if alienation has been happening and the non-favored parent has been missing parent time, then it is counterintuitive, but the correct answer would be send them with the non-favored parent while this hospital staff is able to help prepare them for that. And if the hospital or the residential care staff thinks, hey, this person's not safe to go with the non-residential parent, then obviously they have more work to do, and they should not release the child. And once the child is actually emotionally capable of going with the non-favored parent, that's the time when the child can be released safely. Otherwise, I've seen cases where anytime a child doesn't want to go with the non-favored parent, they just claim that they're suicidal to get out of it. And that freaks everybody out. So we don't want to create an incentive for the child to engage in risky behavior or suicide by allowing them to escape parent time with risky behavior or threats of risky behavior.
All right. Kelly Peterson, we've run out of time. This is very interesting on about the most emotional thing we can deal with, and that's divorce and divorce law and people like you who specialize in this and now specializing in alienation.
Well, it's been a pleasure, Bill.
Thanks, Kelly. Talk to you again.